Hello again. Good to see you back here at Bar 10, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and ring the notification bell so that you can be updated every time we upload new content, which is every day. Question number 1 of this grouping. A man is sitting on a beach chair peacefully and in a relaxed, meditative state when a pickup truck racing on the sand ran down a sunbathing elderly person. The man said out loud, "Oh God, look at what that truck driver did." The person driving the truck was racing and going about 100 miles per hour. Someone called 911. A woman who was sitting on the beach nearby but facing the other way heard the man's outcry. When the case comes to trial, will the court allow both the man and woman to testify about the man's utterances? A, yes, both the woman and the man can testify because it is an excited utterance exception to the hearsay rule that goes to the material issue of the case. B, yes, because this is not hearsay and it is not being entered for the truth of the statement by either witness so that they can both testify. C, no, neither of them can testify because the man was impaired due to being too relaxed from his meditation, and the woman cannot repeat the utterance of an impaired witness. D, no, neither can testify because the utterances do not fit any of the exceptions to the hearsay rule. You have 10 seconds. If you chose A, you'd be correct. Yes, both the woman and the man can testify because it is an excited utterance exception to the hearsay rule that goes to the material issue of the case. Question number 2. Susan owned Goldacre, a tract of land, in fee simple. By warranty deed, she conveyed Goldacre in fee simple to Ted for a recited consideration of $10 and other valuable consideration. The deed was promptly and properly recorded. 1 week later, Susan and Ted executed a written document that stated that the conveyance of Goldacre was for the purposes of establishing a trust for the benefit of Benton, a child of Susan's. Ted expressly accepted the trust and signed the document with Susan. This written agreement was not authenticated to be eligible for recordation, and there never was any attempt to record it. Ted entered into possession of Goldacre and distributed the net income from Goldacre to Benton at appropriate intervals. 5 years later, Ted conveyed Goldacre in fee simple to Patricia by warranty deed. Patricia paid the fair market value of Goldacre, had no knowledge of the written agreement between Susan and Ted, and entered into possession of Goldacre. Benton made demand upon Patricia for distribution of income at the next usual time Ted would have distributed. Patricia refused. Benton brought an appropriate action against Patricia for a decree requiring her to perform the trust Ted had therefore recognized. In such action, judgment should be for A, Benton, because the successor entitled to the trustee takes title subject to the grantor's trust. B, Benton, because equitable interests are not subject to the Recording Act. C, Patricia, because a bona fide purchaser she took free of the trust encumbering Ted's title. Or D, Patricia, because no trust was ever created since Susan had no title at the time of the purported creation. 10 seconds to choose the best option. Best option here is C, Patricia, because as a bona fide purchaser, she took free of the trust encumbering Ted's title. Question number 3. Beth wanted to make some money, so she decided to sell cocaine. She asked Albert, who was reputed to have access to illegal drugs, to supply her with cocaine so she could resell it. Albert agreed and sold Beth a bag of white powder. Beth then repackaged the white powder into smaller containers and sold one to Carol, an undercover police officer, who promptly arrested Beth. Beth immediately confessed and said that Albert was her supplier. Upon examination, the white powder was found not to be cocaine or any type of illegal substance. If Albert knew the white powder was not cocaine, but Beth believed it was, which of the following is correct? A, both Albert and Beth are guilty of attempting to sell cocaine. B, neither Albert nor Beth is guilty of attempting to sell cocaine. C, Albert is guilty of attempting to sell cocaine, but Beth is not. D, Albert is not guilty of attempting to sell cocaine, but Beth is. You have 10 seconds to choose what you think is the best option. Best option here is D. Albert is not guilty of attempting to sell cocaine, but Beth is. Attempt requires 1, defendant intended to commit the crime, and that 2, she took a substantial step towards completing the crime. Regardless of the underlying crime, attempt is always a specific intent crime. At common law, factual impossibility is not a defense for attempting a crime. In this case, however, Albert had no intent of selling cocaine because he knew the white powder was in fact not cocaine. Beth, on the other hand, would be guilty of attempt because mistake of fact is not a defense for attempt. If Beth had completed all of the acts and the facts were as she believes them to be, i.e. that the white powder was in fact cocaine, then she would have committed the crime. Therefore, since Beth had the specific intent to sell cocaine, Beth is in fact guilty of the attempt to sell cocaine. Let's move on to question number 4. A generally applicable state statute requires an autopsy by the county coroner in all cases of death that are not obviously of natural causes. The purpose of this law is to ensure the discovery and prosecution of all illegal activity resulting in death. In the 50 years since its enactment, the statute has been consistently enforced. Mr. and Mrs. Long are sincere practicing members of a religion that maintains it is essential for a deceased person's body to be buried promptly and without any invasive procedures, including an autopsy. When the Long's son died of mysterious causes and an autopsy was scheduled, the Longs filed an action in state court challenging the constitutionality of the state statute and seeking an injunction prohibiting the county coroner from performing an autopsy on their son's body. In this action, the Longs claimed only that the application of the statute in the circumstances of their son's death would violate their right to free exercise of religion as guaranteed by the First and 14th Amendments. Assume that no federal statutes are applicable. As applied to the Longs case, the court should rule that the state's autopsy statute is A, constitutional because a dead individual is not a person protected by the Due Process Clause of the 14th Amendment. B, constitutional because it is generally applicable statute and is rationally related to a legitimate state purpose. C, unconstitutional because it is not necessary to vindicate a compelling state interest. Or D, unconstitutional because it is not substantially related to an important state interest. Take 10 seconds and see if you can find the best option. Best option here is B. It's constitutional because it's a generally applicable statute and is rationally related to a legitimate state purpose. The Free Exercise Clause of the U.S. Constitution states that Congress shall not make any law respecting an establishment of religion or prohibiting the free exercise thereof. However, neutral laws that unintentionally interfere with or burden the free exercise of religion when the government is pursuing other objectives of general applicability cannot be challenged under the Free Exercise Clause. In this case, Mr. and Mrs. Long's religious beliefs maintain that it is essential for a deceased person's body to be buried promptly and without any invasive procedures, including an autopsy. This is at odds with the statute that requires an autopsy by the county coroner in all cases of death that are not obviously of natural causes. The purpose of this law is to ensure the discovery and prosecution of illegal activity resulting in death and has been consistently enforced for 50 years. Therefore, since the statute is a law of general applicability that unintentionally interferes with the free exercise of religion when the government is pursuing other objectives, it cannot be challenged under the Free Exercise Clause. Number 5. Plaintiff sued defendant for breach of commercial contract in which defendant had agreed to sell plaintiff all of plaintiff's requirements for widgets. Plaintiff called expert witness to testify as to damages. Defendant seeks to show that expert witness has provided false testimony as a witness in his own divorce proceedings. The evidence should be A, admitted only if elicited from expert witness on cross-examination. B, admitted only if the false testimony is established by clear and convincing extrinsic evidence. C, excluded because it is impeachment on a collateral issue. D, excluded because it is improper character evidence. Take 10 seconds and see if you can figure this out. Correct answer is A, admitted only if elicited from expert witness on cross-examination. Under the Federal Rules of Evidence, acts of misconduct by a witness that did not result in a conviction are admissible to impeach in both civil and criminal cases if those acts involve lying. Impeachment by this method, however, can only occur on cross-examination of the witness. In this case, this would be impeachment by non-conviction misconduct that bears on truthfulness, so it would only be admitted if elicited from the expert witness on cross-examination as noted. Question number 6. Anna owned Blackacre, which was improved with a dwelling. Beth owned Whiteacre, an adjoining unimproved lot suitable for construction of a dwelling. Beth executed and delivered a deed granting to Anna an easement over the westerly 15 feet of Whiteacre for convenient ingress and egress to a public street, although Anna's lot did abut another public street. Anna did not then record Beth's deed. After Anna constructed and started using a driveway within the described 15-foot strip in a clearly visible manner, Beth borrowed $10,000 cash from the bank and gave bank a mortgage on Whiteacre. The mortgage was promptly and properly recorded. Anna then recorded Beth's deed granting the easement. Beth subsequently defaulted on her loan payments to the bank. The Recording Act of the jurisdiction provides as such: no conveyance or mortgage of real property shall be good against subsequent purchasers for value and without notice unless the same be recorded according to law. In an appropriate foreclosure action as to Whiteacre brought against Anna and Beth, bank seeks, amongst other things, to have Anna's easement declared subordinate to the bank's mortgage. This would mean the easement will be terminated by completion of the foreclosure. If Anna's easement is not terminated, it will be because A, the recording of the deed granting the easement prior to the foreclosure action protects Anna's rights. B, the easement provides access from Blackacre to a public street. C, Anna's easement is pertinent to Blackacre and thus cannot be separated from Blackacre. Or D, visible use of the easement by Anna put bank on notice of the easement. Take 10 seconds and choose the best option. The best option here is D, visible use of the easement by Anna put the bank on notice of the easement. Without notice means without both actual notice and constructive notice. Inquiry establishes knowledge of facts that a reasonable investigation of the land would reveal. Record establishes knowledge of facts that a reasonable search of public records would reveal. In this case, Anna did not record Beth's deed granting to Anna an easement over the westerly 15 feet of Whiteacre prior to the bank recording its mortgage on Whiteacre. However, Anna did construct and start using a driveway within the described 15-foot strip in a clearly visible manner. Therefore, since a reasonable investigation of the land by bank would have revealed Anna's easement, the bank had constructive notice of Anna's easement. Question number 7. After being fired from his job, Mel drank almost a quart of vodka and decided to ride the bus home. While on the bus, he saw a briefcase he mistakenly thought was his own and began struggling with the passenger carrying the briefcase. Mel knocked the passenger to the floor, took the briefcase, and fled. Mel was arrested and charged with robbery. Mel should be A, acquitted because he used no threats and was intoxicated. B, acquitted because his mistake negated the required specific intent. C, convicted because his intoxication was voluntary. Or D, convicted because mistake is no defense as to robbery. Take 10 seconds and see if you can choose your option. The correct answer is B, acquitted because his mistake negated the required specific intent. Robbery is larceny plus force or threat of immediate harm. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. If the defendant believes that the property is his or her property, even if the belief is unreasonable, the defendant is not guilty of larceny. In this case, Mel mistakenly thought the passenger's briefcase was his own. Since Mel thought the briefcase was his, Mel's mistake of fact negates the intent to permanently deprive element of the robbery. Therefore, Mel should be acquitted because his mistake negated the required specific intent. Question number 8. The mineral alpha is added to bodies of fresh water to prevent the spread of certain freshwater parasites. The presence of those parasites threatens the health of the organisms living in rivers and streams throughout the country and imperils the freshwater commercial fishing industry. Alpha is currently mined only in the state of Blue. In order to raise needed revenue, Congress recently enacted a statute providing for the imposition of a $100 tax on each ton of alpha mined in the United States because it will raise the cost of alpha. This tax is likely to reduce the amount of alpha added to freshwater rivers and streams and therefore is likely to have an adverse effect on the interstate freshwater commercial fishing industry. The alpha producers in Blue have filed a lawsuit in federal court challenging this tax solely on constitutional grounds. Is this tax constitutional? A, no, because only producers in Blue will pay the tax and therefore it's not uniform among the states and denies alpha producers the equal protection of laws. No. B, no, because it is likely to have an adverse effect on the freshwater commercial fishing industry and Congress has a responsibility under the Commerce Clause to protect, foster, and advance such interstate industries. C, yes, because the tax is a necessary and proper means of exercising federal authority over the navigable waters of the United States. D, yes, because the power of Congress to impose taxes is plenary. This tax does not contain any provisions extraneous to tax needs or purposes, and it is not barred by any prohibitory language in the Constitution. Take 10 seconds and choose what you think is the best option. Best option is D, yes, because the power of the Congress to impose taxes is plenary. This tax does not contain any provisions extraneous to tax needs or purposes, and it is not barred by any prohibitory language in the Constitution. Congress has the power to tax for the general welfare, and taxes will be upheld if the taxes bear some reasonable relationship to revenue production or if Congress has independent authority to regulate the activity being taxed. This tax is constitutional because nothing in this question indicates that this tax does not bear some reasonable relationship to revenue production. Tax is $100 per ton of alpha mined, nor is it barred by any prohibitory language in the Constitution. Question number 9. In which of the following situations would defendant's mistake most likely constitute a defense to the crime charged? A, a local ordinance forbids the sale of alcoholic beverages to persons under 18 years of age. Relying on false identification, defendant sells champagne to a 16-year-old high school student. Defendant is charged with illegal sale of alcoholic beverages. B, mistaking defendant for a narcotic suspect, an undercover police officer attempts to arrest him. Defendant, unaware that the person who has grabbed him is an officer, hits him and knocks him unconscious. Defendant is charged with assault. C, defendant, age 23, has sexual intercourse with a 15-year-old prostitute who tells defendant that she is 18. Defendant is charged with the felony of statutory rape under a statute that makes sexual relations with a child under 16 a felony. D, relying on erroneous advice from his attorney that if his wife has abandoned him for more than a year, he is free to marry. Defendant remarries and is subsequently charged with bigamy. Which do you think mistake would be the most ideal defense in? Correct answer is B, mistaking defendant for a narcotic suspect. An undercover officer attempts to arrest him. Defendant, unaware that the person who's grabbed him is an officer, hits him and knocks him unconscious. Defendant is charged with assault. Self-defense is a valid defense to assault and or battery charges. The rule is that a non-aggressor victim may use a non-deadly force in self-defense anytime the victim reasonably believes that force will be used against them. In this answer, defendant, who was not the narcotic suspect, was unaware that the person who grabbed him was an undercover police officer and had no real reason to believe him to be an undercover police officer. As such, the defendant was justified in using non-deadly force in self-defense, since due to his reasonable mistake, he reasonably believed that force was being used against him. Our final question of this grouping, question number 10. A little more than 5 years ago, Len completed construction of a single-family home located on Homemaker, a lot that Len owned. 5 years ago, Len and Tina entered into a valid 5-year written lease of Homemaker that included the following language: this house is rented as is, without certain necessary or useful items. The parties agree that Tina may acquire and install such items as she wishes at her expense, and that she may remove them if she wishes at the termination of this lease. Tina decided that the house needed, and she paid cash to have installed, standard size combination screen storm windows, a freestanding refrigerator to fit a kitchen alcove built for that purpose, a built-in electric stove, an oven to fit a kitchen counter opening left for that purpose, and carpeting to cover the plywood living room floor. Last month, by legal description of the land, Len conveyed Homemaker to Pete for $100,000. Pete knew of Tina's soon expiring tenancy, but did not examine the written lease. As the lease expiration date approached, Pete learned that Tina planned to vacate on schedule, and learned for the first time that Tina claimed and planned to remove all of the above listed items that she had installed. Pete promptly brought an appropriate action to enjoin Tina from removing those items. The court should decide that Tina may remove A, none of the items, B, only the refrigerator, C, all items except the carpet, and D, all of the items. Take 10 seconds and tell me what you think is the best option. The best option here is all items. Letter D. A fixture is a piece of personal property that is attached to land or a building that is objectively regarded as an irremovable part of the real property. While attachment objectively shows the intent to permanently improve the property, any express agreement between the landlord and tenant will control whether or not the personal property is a fixture. In this case, Len leased Homemaker to Tina for 5 years, and the lease included the following language: this house is rented as is without certain necessary or useful items. The parties agree that Tina may acquire and install such items as she wishes at her expense, and that she may remove them if she wishes at the termination of the lease. This express agreement regarding fixtures would control, and as such, Tina may remove all of the items that she had installed, or none of them, whatever it is that she wishes to remove. Thank you for joining us again on Bar 10 Test Prep, where we try to prepare you for the bar exam 10 questions at a time. Please like, subscribe, and ring the notification bell for this video so that you can be updated every time we upload new content, which is usually every day.